Good morning. We now call to order the committee conference on House Bill 307. And we'll just go around and let everyone introduce themselves, and then we'll begin.
Representative Wallace, Rockingham 12, Town of Danville.
Representative John Burt, Goffstown, Ware, and Deeren, Hillsborough District 39.
Hi, I'm Becky Whitley. I represent District 15, which is Concord, Henniker, Hopkinton, and Warner.
Harold French, Senator, District 7.
Sharon Carson, Senator, District 14.
Representative Darrell Abbas, district, it's Rockingham County, District 8, which is the town of Salem. And we'll just start by going around the room and let everyone I'll let our colleagues in the other bodies start with their position if they want to make any comment on the Senate amendment.
Thank you, Mr. Chair. It seems that the one sticking issue, and I believe there's just one, is over the Senate's omission, or we took the word use out. We tried to walk a very, very fine line with this particular bill. We support the Second Amendment and the right of an individual to bear arms. And we felt that when we were talking about public property, no matter what, the individual has the right to bear arms on public property. I think schools are exempt because of federal law, but there should be nothing in place to stop you from carrying or bearing arms if you are on public property. I think where we ran into problems concerned the use of those guns on public property. That we recognize that municipalities have control over public property, and in many towns and communities around the state, they have said that you can't use those guns on public property. And we're talking about parks, we're talking about walking trails, and other things that are open to the public. I can tell you that there have been instances in my community where people have been on public property shooting their guns, and in one instance it went through the window of a business cafeteria. Just irresponsible, and because of that the town of Londonderry banned the use of guns on in the Musquash, which is a town-owned property. I see the tension here between the right to bear arms and the right to use arms. And we do tend to regulate the use of those arms, where they can use them and where they can't. So the Senate addressed the use of the weapon, not whether or not you can bear the weapon. You have every right to do that, but it deals with the use of the weapon.
Just the same, what Senator Carson just said. I did not see where it was necessary to have the word use in there, so I was fine with removing it. Obviously, the lawful use for protection would be already guaranteed under law, and the recreational use would not be.
If I can, Mr. Chair, we felt that New Hampshire's stand your ground law was key, that if you were on public property and you were attacked or you came to the defense of another, that New Hampshire stand your ground would cover that individual for using the gun at that particular time. So we did not feel the need to address that in this legislation.
Representative Burt, do you wish to?
Yes, thank you, Mr. Chairman. The last time I looked, shooting anybody's window out is against the law. So I would assume that person hopefully was prosecuted. I know the Hillsborough County, behind the Hillsborough County Nursing Home is public land, and there is a people go up there and shoot in the woods. You hear it all the time. I hear it from my house. But they're respectful, because I'm assuming if they hit the nursing home, I'm thinking people are going to go to jail. So that we have current laws. The word use has to be put back in. And the reason is I have a selectman in Goffstown that's from Chicago. I think it's pretty clear what her intention is, and that is to regulate guns in Goffstown. And if I understand the word use from what I'm being told by several attorneys, gun groups, that the word use, if removed and stayed removed, could cause or allow the town to regulate gun ranges, a private shooting range on your own private property. That's what I'm being told. Even on private land, so public and private land, they can ban shooting ranges in the town. Come to the schools, I know Hanover and other towns have tried to ban guns in their schools. New Hampshire is one of the few states that allow guns in our schools. When they tried to ban it last term, a lot of teachers called me and said, please don't allow this to happen, because they wanted to carry guns to protect the children in case of a shooting. So luckily, it did pass the House and the Senate, and it got over to the governor, and he vetoed it. I guess the other red flag for me is that the New Hampshire Municipal Association supports this, because they know that the town will be able to regulate the use of guns with the word use removed out of here. So I hope we can come to an agreement, to put this word back in there, because I don't want to give my one selectman that is from Chicago area the opportunity to restrict anybody in Goffstown or any district or any town, city in New Hampshire that may follow the use of firearms on their private property or in public properties that is allowed currently. Now, I understand that, the Moskowitz, is an issue. I think there's other ways to deal with that. So I hope that we can come to an agreement and put that word use. Thank you.
Senator Carson?
Thank you. Thank you, Mr. Chairman. I think what we did specifically was look at public. We did not look at private property. And I think, and I can't really speak for the rest of the Senate, we'll have to discuss it, that we would be open to making whatever exemptions we needed for private property, I think is entirely appropriate. Because after we passed this, we heard that, oh my goodness, they're going to regulate private property, especially gun ranges. And we don't want that to happen. But the ultimate question is, who governs the property that's owned by the public? Is it the public and their elected officials at the local level, or is it going to be the state? There is an existing statute, and I don't recall off the top of my head what it is, that the legislature years ago gave the municipalities the right to regulate their own land, their public property within their confines. And so are we going to overrule the vote of the people if they decide we do not want people firing guns on our public property? Or is the legislature going to say you can't do that? And I think that is where things get really, really sticky. And I understand, Representative, your concern about having someone who is comes from a place that is anti-gun. I think we all know that Chicago, the city of Chicago, has adopted a number of anti-Second Amendment laws that just don't work. I mean, I think Chicago has one of the highest death rates by firearm in the nation, and it doesn't work. But it's their law. That's what they decided to do here. In the town of Goffstown, or whoever this person is representing as a selectman can easily be voted out at the next election. But I think where we're talking about public property, we have to be very, very careful because everyone is the public, and you have to take into account what the public wants in that particular community. And should the state have the ability to override a municipality? And I think that's why the municipal association supports this, because they feel people in the municipality should be able to govern the property that they own rather than the state. So I thought what we did was we recognized an individual's right, constitutional right, to bear arms. No one should take that away from them unless there are specific circumstances. But they should be able to take their gun if they decide to go on a nature walk or on a rail trail or a walk through any kind of property that's open to the public. No one should tell them you cannot bring that gun on private property. Absolutely not. We're talking about when can you use it on public property? A lot of these rail trails and sometimes these different parks, there are people that are all around them, people that live in their homes, and people that go out there and they shoot. These folks don't want them there. They don't want them shooting in the woods behind their house. I backed conservation land in Londonderry. There are people out there all the time shooting. Doesn't bother me. I have 2 dogs in the fall. I put orange vests on them. They're in my backyard, which is all chain linked. But there's a chance that something could happen. I take that precaution to protect my animals. What happens behind there, it's open for hunting. Have fun. You can do that. And that was a decision that was made. And that's okay. But there are other places where there are no fences and people just go back out there, and quite often representative people are irresponsible. We have a number of people that decide they want to come up from Massachusetts and come shooting in Londonderry on our public property. And the town has addressed that, and they've closed the Musquash for shooting because of irresponsible people. But the question is, do we take that right away from the municipalities? And I don't have an easy answer for that. I do think, though, that with this bill, it was a little contentious because we went ahead and we said, hey, listen, you can carry your weapon at college. That we got a lot of pushback from that. But I think it's appropriate. I don't see why a college should ban a student from having a gun. If they are a legal gun owner, they have every right to have that, unless they've done something wrong, and there are laws in place to take care of that. We heard stories about, well, all the frat parties and people have guns, and people are. It's like no. Most gun owners are extremely responsible, and they're taught to be responsible. But I think if we can address the private land issue and assure people that if you are on your own property, you're on your own property, and protect the gun ranges, I definitely think we need to do that within this piece of legislation. I think we would be open to doing that.
Senator Carson, I can ask, in respect to what happened with the window getting shot out in Londonderry, how close was that to the person firing the firearm, the structure?
They were, in fact, they were using something that really they shouldn't have been using, and they were caught. Our police did catch them. So.
But in respect to where the shot was fired to where the building was, like how close were they? Approximately.
Oh, I can't answer that question. They were not adjacent to the building. They were just being completely irresponsible. They were in the woods and they were firing at things, and they just, I don't know, miscalculated, whatever. And there is, if you were to, because this is up near the airport, which is another issue. The Manchester Regional Airport, people are using their weapons in the property around the airport. Just not a good thing, because the musquash is, has parts of it that are around the airport.
But if they were, when you say caught by the police, were they arrested?
Yes, and prosecuted. So it was,
Is there an existing law, though, that if they're violating an existing law, if you're allowed to use a firearm on public property, you still got to respect the other laws in the books. If you are acting in any type of reckless manner, you're still going to get arrested, even if you're, say, allowed to use it. You can't endanger somebody. If you're at a shooting range and you engage in reckless conduct while using a firearm, you're going to get arrested. So I
Right.
guess by taking use out, because under my understanding, under current law, use is in current law. So if this were to not make it out of this conference today, the problem with the word use is not solved. It's still going to be
Right.
an existing law. So
mhm.
perhaps that issue can be solved on a standalone bill in another year. Because I look at this policy is we have a preemption law that really doesn't have an enforceability side of it. The purpose of this was to have a way to enforce our state's preemption laws. I think that the intent of what this does a good job of doing that. Yes. Yes. It's allowing you to enforce it, and it puts a procedure in place for that. But all I'm saying is, we don't come to an agreement here today, the use problem is still going to be a problem, and the lack of teeth.
Mr. Chair, I would agree with you completely because of conflicting statutes. And that's what we saw, was the conflicting statute that gives the municipality the right to regulate land under their control versus here. That conflict already exists. And what we tried to do was address that particular conflict that's in place and say, look, if the municipality is going to regulate, you have the right to do so, but you cannot tell someone they cannot bring their weapon into or onto private property. You do have the right to say you can't use it here, which they do already in statute as well. And that is, quite frankly, what I think needs to happen is the legislature needs to put those statutes side by side and address them and reconcile them. And that has not happened.
But wouldn't the one that was the most recent RSA supersede the prior one? Am I incorrect when I say that? So if there is a conflict, anyone have any insight? My understanding is it would supersede the prior one.
This would. Yeah, this would.
Yes, so we would be now removing use, and therefore every community could regulate use out they're going forward. And the problem with that is it's when in Rome. The
I
idea is
have a question if I could. And I apologize. I somehow was assigned to two committees at once and I've yet been able to clone myself. Have we discussed what use means? Have we discussed, in other words, if we go, I'm allowed to carry my firearm, according to what the senator just said, I'm allowed to go hunting or what, but if I squeeze the trigger for whatever reason, have I violated their law that they've put in against use?
it was somewhat, my understanding was that if for self-defense purposes, that it's believed that you're not violating the law. I think
Or hunting?
I know the municipalities are preempted from regulating hunting as well. That's my understanding.
I'm worried we're going to set up a confusing.
Exactly, and that's why I would think having a standalone debate on use as opposed to letting this fall apart. I think having a public hearing on the word use and all that would be the way to go. Because I think at the same time, you have communities that are clearly passing local ordinances that violate the state law, and yeah, you can go file an injunction, but I mean, I think your typical layperson doesn't know how to do that. It's not the easiest process, and it's expensive to hire an attorney. This gives you 307 lets you get your legal fees recovered.
So, Mr. Chairman, what I'm concerned about is if a municipality by vote, a vote of the people, decide we don't want them to shoot on this particular property, are we saying that you can't do that? Are we telling people you don't have the right to vote
When-
on that particular issue?
Well, I'm telling you, the current law already prevents that. But there as another RSA that this applies to use if it's within 300 feet of a building, and also says applies to parks, outdoor public places for outdoor public gatherings, and playgrounds. So we're not saying all public property. There's already RSAs that prohibit the use of a firearm at a park or a playground. So there are some restrictions already. Now, I think the property you're discussing in Londonderry, I'm not certain that would fall under any of these. I'm referring to RSA 644:13. I'm not clear that would fall under any of those, but we're talking about a specific type of public property.
So I just want to make sure I understand this. If I'm a private property owner and I do not wish to open my property to hunting, I have to go out and I have to post it and I have to say no hunting. But the municipality on the property that they own, they can't do that?
Under existing law today, that's correct. But that's existing law. So I'm saying by walking away from this, and if I'm saying something that's not entirely accurate, please correct me. I'm really going off a lot of memory up here. Representative Wallace?
Thank you, Mr. Chairman. Just a simple question for my members from the other body. What about the simple modifier lawful use? Putting that back in.
Okay. I think, we can consider that.
Lawful use is just that, all lawful purposes. So if somebody was being negligent, as you described in the already adjudicated situation in your hometown of Londonderry, wouldn't have put that, this bill would allow prosecution to go forward because it would not be a lawful use of the firearm. Would you agree, Senator?
I could agree with that.
Representative Roy?
Thank you, Mr. Chairman. Just to the group in general, I think I understand what Senator Carson is saying about localities getting together and a community of 300 people all vote no, we don't want any guns. But what if that same community of people got together and said, you need a permit for speech? I mean, the Second Amendment is a fundamental right of the citizens. So no locality or municipality, no matter how well intentioned, is allowed to take away fundamental rights just because the mob, if you will, decided they don't want it. It's a fundamental American right. So we would not tolerate it with any other constitutional right for our municipality to say you can't do this here.
Right.
Although regulating it is legitimate, but we have to be very careful because it is a fundamental right.
Representative Whitley? Senator Whitley, sorry.
Thank you, Mr. Chair. So just to that point, every right that we have under the Constitution is important. Every right. And not one right should be elevated over another. And so what you're describing would surely be challenged and not be constitutional. This, permit for right, exactly. So if a government decides to act, right, then they have to have a governmental interest and it needs to be balanced, right? Exactly. So, but I think it gets lost in the Second Amendment conversation. It is a right under the Constitution and people interpret it different ways, but it should not be elevated over every other right. And so I think what Senator Carson is describing is, individuals have property rights, and in New Hampshire, we care deeply about property rights. And I think we're also talking about, town-owned property is the property of the entire municipality, and there are property rights there that need to be balanced against the Second Amendment. And let me know if I'm speaking incorrectly.
But all the point I'm trying to make is a separate standalone bill can be filed to address use under RSA 644:13. I'm just saying the issue of use is one topic. This has to do with having some way to enforce the preemption laws. For the communities that completely ignore the state law, if we're going to have any type of preemption whatsoever, there needs to be a procedure to enforce it and to not be something that's going to be a tremendous financial burden. As someone, you have a legal background, I'm sure you know that legal expenses can really pile up for someone who's trying to simply address this. This gives them that. And then why don't we have the use conversation on a separate bill?
So just to respond to that, and by the way, I was a public interest lawyer, so I was never making the big bucks as a lawyer.
But I'm
But
sure
to
I'm
respond
sure the
to
folks you interacted with though were.
but to respond to that, you know, if that's the case, then let's just strip the law. I mean, I'm not saying that this is something I would support, but if that's the case, then just strip the rest of the law and just keep the penalties.
Senator
Thank you.
Carson?
Because Representative Roy came in late, what we did was we recognized the right that no municipality has the right to tell any gun owner they do not have the right to take that gun onto any public property. So, I mean, schools, we know public schools are different, but whatever public property they own, no municipality can tell me, Senator French, you, anybody else who owns a gun and carries a gun, that you cannot take that onto public property. I think that was something that we felt very, very strongly, but our concern was the use. And it is that tension between gun owners and people that own the property. And the municipalities own that property. And do they have the right to regulate the use of that weapon on public property? That is the ultimate question here. And there are conflicting statutes. One statute says they do, but then you've got gun laws over here that conflict. And that's what we're dealing with, is this conflict. But I hope we can all agree that no municipality has the right to tell a lawful gun owner that they do not have the right to take that weapon onto publicly owned property.
Representative Wallace?
Thank you, Mr. Chairman. And I agree with you, and I think that the lawful use of a firearm would also cover any concerns that some of us have about the general use policy. So, for example, it would allow and provide for the protections on private property as well, because lawful use would be all permitted purposes on private property. You know, and adding that lawful use, it keeps everything on the up and up and removes the ambiguity.
Okay.
Representative Silver's here. You are the prime sponsor of HB 307. You heard a comment by Representative Wallace about perhaps putting the word use back in, but it's saying lawful use. Do you have any comment on that? Any opinion you wish to?
Thank you, Mr. Chairman. The existing preemption law contains the word use. The Senate amendment would take that out, reenact the preemption law, adding some enforcement mechanism, but take the word use out. So there is the statute, the other RSA, dealing with unlawful use of firearms in different parts of a municipality, already exists. So what the Senate amendment does, it takes the word use out. I don't see that there's any reason to change the existing language of the preemption law. All we're trying to do is to add enforcement. I'm sorry?
What if we add law, use back in law, which would mean
I haven't considered that. I think as the preemption law exists with the word use in there, there is a implied requirement in law that everything you're permitted to do in law must be lawful. So it's already there. It's implied in law. Everything has to be done lawfully. If it's not done lawfully, there's an RSA that already governs it. So I don't know that
Respectfully, we spend a lot of time and effort cleaning up ambiguities in the law on a very regular basis around here. Would you
Right.
agree?
Mr. Chair.
So, and just to understand the point, the unlawful use, we don't need to, by saying lawful use, we're basically saying the unlawful use is illegal, which is already illegal. Which is a
Yes.
point well taken, Representative.
Mr. Chair, if I might, if we could take a recess, so the Senate can caucus?
You may.
Thank you.
Take all the time. We'll be in a short recess.
Huh? Yeah, make sure you turn your mic.
I call a committee of conference meeting on House Bill 1011 to order. And I guess my opening statement would be, I was curious as to why the repeal. And we discussed it, and I understand what the reasoning was, but by repealing that section, we take out the restitution part of it. So I'm wondering if we can come to an agreement where on Roman numeral 4, we can only we just take out shall be guilty of a violation and leave the restitution in. We won't have to renumber anything, it's just a simple change. But the reason for House Bill 1011 was when people vandalized property. We had vandalism at the State House. We know who the vandals were, but they wouldn't pay. All it was a violation. It was they didn't have to pay in their mind. You got to have a hammer hanging over their head. That was the reason for the bill, and by deleting that section, we deleted the restitution. So I think if we can talk about that for a minute.
What we did was we put the bill back to the way it was before, prior, I believe it was 2019 to 2020, it was changed, the statute itself was changed. And we went back, again, we went back and looked, and we went back to the statute, it was the way it was prior to the change. Oh, I'm sorry, I keep forgetting about these. It's gonna, I think this whole thing is gonna take a little while to get used to. What we did, Mr. Chair, was we just went back to the statute as it had been prior to I think it was either 2019 or 2020 when it had been changed. The penalty had been lowered, and we wanted to make sure that the higher penalty was in place, because I think at the time that it was changed, there were a lot of issues with public property being defaced, and that was statues and things that were being torn down, and the penalties were lowered, and we did not want that in place. We wanted the higher penalty to be in place. But if you are just looking to have the restitution piece, I don't think that, I can't speak for my committee members right now, but I mean, I think we can definitely consider that, if that's the only thing you really want to do.
I'm learning too. That was the reason for the bill. Terry Paff came to me in a previous session, and we tried, and we didn't get it because of COVID.
Mm-hmm.
So we tried it again, and obviously we didn't look into it as carefully as you did.
Mm-hmm.
But the restitution piece was important, because when they vandalized out in front of the State House, they caught the vandals, and it was a violation.
Mm-hmm.
Yes.
And even bringing it back to the misdemeanor with a stiffer penalty, it doesn't provide for restitution. It provides for a fine, which may or may not cover, and it doesn't direct where the fine goes. Generally, fines go to the general fund, which
Right.
doesn't do the restitution. So that's why we wanted the restitution.
Okay, so are you saying it's an either or, that they pay a fine or a restitution, or pay a fine and a restitution?
I would say it should be either or, up to the judge. I don't know what you guys think.
Well, the restitution is to the whoever's property has been damaged as a result of the vandalism. The fine is something that's just paid kind of as a penalty for the offense.
Right, but I don't want to make it so that it's impossible to pay and then nobody gets anything and they just end up in jail. I'd rather see the money get to where it belongs. So if it's, I'm either way, I'm okay. I don't want to do double.
As written, you can't draft the RSA to say this, but my understanding in the world when this is in a court, when people work out a deal, sometimes providing restitution to the property is something that's considered favorable towards, although the county attorney's not gonna help negotiate a private civil settlement, but they're gonna, basically, if you pay restitution or are willing to, that's something that Luigi's sometimes considered.
Well, let me ask, do you feel that it's more important to pay restitution rather than a fine?
I think we're talking about public property here, and if they don't pay, the taxpayers pay. That's my feeling. And if they damage something that's, well, of historical value or something that can't be replaced, that's up to the judge. Every case is different.
But do you think that if someone destroys something of historical value and they're fined $50,
That doesn't cut it.
it doesn't cut it? And I was thinking that you've got many communities in New Hampshire. You have your town center, and you have your statues of your Civil War veterans, and you can have. I know in Londonderry we have. They sold bricks with names of people in honor of, and it's all part of this town common area. And they go out and seed it, and you've got the grass is growing nicely, and somebody decided they wanted to go 4-wheel on it and ripped up all the lawn. $50 fine is not going to compensate for the damage that's been done. So that's why I asked, what do you think would be more appropriate? Because I agree, I don't think it would be appropriate, a fine and restitution. Is it more important to pay restitution than a fine?
My basic feeling is if there's a jail sentence involved, if I were the judge, I'd impose the jail sentence, suspend it, provided the guy makes restitution. And that's the carrot and stick that we were looking for.
Okay.
Yeah, restitution. Yeah. If I may, I think that if we put an either or somehow, in other words, because somehow there might be something where restitution's not appropriate. I'm trying to think of a situation where there wouldn't be necessary restitution, but I can't think of one. So maybe we just do restitution. Yeah.
Well, if I may, Mr. Chair, if you have someone who has destroyed a historical document, it can never be replaced. It's now gone. And it would be up to the court to determine what is the restitution. So.
I agree with that, and I'm not the judge. I think in cases where we give the tools to the judge, let the judge make the decision.
Okay, can we take maybe 10 minutes, Mr. Chair, for the Senate to caucus, and we can and we will be right back.
Sure.
I'm not the chair.
Oh, I'm sorry.
We'll be in recess until you come back.
Okay. Thank you. Appreciate it. Did you schedule that other one? Okay. All right. Yeah.
All right, we'll reconvene the committee now and, on House Bill 1011.
Mr. Chairman, we'd like to offer this as an amendment that I think satisfies the intent of the House.
That's good.
Okay.
I think so.
Yeah, yeah, that's, yeah, violation should be struck. Okay. Yeah, because yeah, you had violation in the brackets. Yeah. Okay. Yeah. Okay. Okay, so I think we are in agreement on the language, so I believe the procedure is we will accede from our position, you will accede from your position, and we will adopt this as the new position. And we will, the Senate will agree to that.
Then, who's gonna make up the amendment? I'll take care of that. That's what I was afraid of.
It's a House bill, Representative. That's why we brought Representative Abbas in to, make sure we were getting the language correctly from two attorneys, and I'm sure Representative Abbas will be more than happy to help you get this done.
Well, that sounds good.
We still messed up, too, because that's right.
See? So
Then
you
I-
can have all the attorneys in the room that you want, and there's still mistakes being made, so.
Well, if you have 5 attorneys, you got at least 6 opinions.
Yeah, right.
She's a fellow senator. I'm not gonna criticize her. So, okay, so I think we're,
I'll
Thank
see
you.
you on Friday.
yes, Friday,
Yes.
yes, I know. I had to stop and think about what was going on Friday. So, okay.
all right.
I'd
Yeah,
like to thank
w-
Mr. Lehman for helping us with making sure we get this language
I thank him as
absolutely
well.
correct.
Thank you very much.
Thank you. So we will now
Okay.
close the hearing and
Thank you.
go on about our other business.
We'll now call the order the committee conference on House Bill 1333. Just quickly let everyone introduce themselves for the record.
Representative Wallace, Rockingham 12, Danville.
Representative Rhodes, Cheshire 15, Winchester, Richmond, Marlborough, Swansea, Troy.
Representative Roy, Rockingham 32, Candia, Deerfield, Northwood, Nottingham.
Becky Whitley, I represent Senate District 15.
Harold French, Senate District 7.
And Sharon Carson, Senate District 14.
Representative Darrell Abbas, I represent Rockingham County District 8, which is the town of Salem. Just before we begin, the Senate version and the House version, there's no conflicting language amongst the two. And the Senate version, there was a Supreme Court case that came down. There was some conflicting language between some of the regulations and some of the RSAs. My understanding is that the Senate amendment, what it would do, it would address that inconsistency, which I think is a good thing, because that should be solved right away. However, the underlying bill has been completely removed. I am the prime sponsor of that bill, and I thought it was a good policy. What it did is for third and fourth offenses, expanded the look back period from what is now 10 years, 20 years. We're talking about drunk driving convictions. We passed this in the House Criminal Justice Committee last term. It passed. It was ultimately tabled, but then at the same time this year we passed it, and I think it went on the consent calendar. So my understanding, they thought the 20-year look back period for repeat offenders was too long of a time period. So I guess the question is what we want to do about it. If anyone has any comment, we can go around the room and Senator Whitley.
Thank you, Mr. Chair. So on the look back issue, we have to balance this with what we're trying to accomplish. And if we're trying to accomplish getting folks to not reoffend again, putting them in jail is not the right way to do it. If people are offending this many times, it's because they have a disease. They have, they are alcoholics likely. And to get them to not reoffend again is to get them into treatment. Maybe it'll take a third time. Maybe it'll take a fourth time. We know that the way that this disease progresses, that people need to attempt treatment many times. Putting them in jail is not going to help them get better. And so I think the Senate thought that look back was a little bit too long, and thought the existing law, we didn't hear many problems with it. It's a good policy because it punishes people when necessary, but also allows people to continue to get treatment when necessary, which is the most effective way to get them to not offend.
Yeah, I had a problem with 21 years old, get 2 DWIs back to back, and then the third one comes at 41 years old, and we're holding him to this long look back. So I was against the 20-year look back.
Can I just say ditto? I mean, we did have great discussions, I think, about this particular issue. I think Senator Whitley makes a great point about her reason why 20 years might be excessive, as well as Senator French. 20 years is a long time, and a person can change within 20 years, and you could have an 18-year-old or 20-year-old go through a period of their life where they might be drinking a little bit too much, and they get a DUI, and it's going to follow them around for the next 20 years. And if they should offend for a third time, there's some extremely stiff penalties. So I just felt that 20 years was just too much of a look back, way too long.
I respect that, alcoholism is a disease, but offenders of this crime are not necessarily alcoholics. There's people who commit this offense, and we were just making the presumption that they are. So my concern is, in the way I understand how the law would work, in order to be charged with a second offense, you would have had to already been convicted of the first offense.
Mm-hmm.
So if you are charged with your first offense and get arrested again, that would be another first offense. You actually have to have the conviction before you move on to the next. Your license is going to be suspended for a portion of that time period. The second offense, same thing. We hear about people on, you see in the news, and it's all over the country, you'll come across it. This person's been arrested or convicted 5, 6 times for drunk driving. What happens is when you have such a short look back period of 10 years, is the person's really getting convicted of first and second offenses several times over. So we're not necessarily addressing the problem. It's not about throwing someone in jail, but we have someone who, I think in a 10-year time period, has an ample opportunity to seek help for the condition they have. And we have a situation that's endangering the public. So if 20 years is too long, I respect the opinion on that, but I guess I would be open to see what we're willing to compromise on. Obviously, the other section of this, the amendment from the Senate is important, addressing drunk driving. If we care about enforcing those penalties and doing it properly, why would we not consider a harsher penalty for, if you're going to continue? It's not a harsher penalty, but extended look back period for repeat offenders.
Mr. Chair, if I could.
Representative Roy?
Also, to your point, what we're not taking into account in a discussion is pleas. So you get arrested for a DUI, you don't necessarily get convicted. You could plead. So now you've got someone who's been arrested for numerous DUI, but you can only look at the convictions in the look back period. So in that 10 years, they could get another and another. And if they plead to a lesser offense or it gets continued without a finding, then the lookbacks don't trigger. So I think that an extension of the current look back period, I think, is definitely in order, just because of the fact that not all of them end up in convictions because they plead to something else. 20 years, okay, as Daryl said, that may be too much. Is there a number that may be acceptable to the Senate?
Representative Rhodes?
Thank you, Mr. Chairman. I want to echo what Representative Roy said. He actually said it before I had the opportunity, is that many times these crimes are pled down. Exactly what he said. I can't say it any better. And that does not take away the fact that, yes, you may have a person that does have a disease, but you also have a person that may have lost their life because of another person's disease. And that does not mean that the person has not had the opportunity or has not already gone through a treatment program many, many times. There are several programs out there to help people that have mental illnesses, diseases of all sorts. That does not mean that you cannot hold a person accountable for their own actions whenever they're putting someone else's life in danger repeatedly.
Thank you, Mr. Chair.
Senator Whitley?
Yeah, so I think, the Senate made our decision on the look back, and I think it would be helpful for me to see any, because I don't want to just sort of speak on what happened in other states or sort of rhetoric. It would be helpful if the House had any information about this actually being a problem in New Hampshire. That would be helpful. I think any change to a look back, we need to have some pretty solid data behind it.
Yes, well, that is an example. The problems with that one is there was no, those are all still first offenses because there was no convictions. They're all separate. So whether there's 5 separate charges from separate incidents, you can have a conviction on 1, 2, 3. Who knows? So it's hard to. That's more of an issue of bail, if you ask me. Yeah. In respect to the data, I mean, I wouldn't say drunk driving is a problem that's overwhelming the state that we need to duck for cover here, but it's still an issue that's affecting us. And all I'm saying is, if you look at the penalties for a second offense, there's two different categories you can fall in. One of them, if you're arrested within, I think it's within a 2-year period of the first offense, but assuming you don't fall in that, you're looking at the minimum. It's 12. You can have a 17-day sentence, but 12 of those are suspended. So you would have 5 days must be served in the House of Corrections. For this is second offense. The third offense is it's 180 days, but you can have 150 suspended. So you're looking at 30 days. All right. So we're talking about an additional 25 days, assuming your first and second were not within a 2-year time window. For the fourth offense, it's also it's the same 180 days, 150 of which can be suspended. So between the third and fourth, the amount of time served is actually in jail is it's the minimum sentence is the same. It's the second offense. If the second offense is within 2 years of the first offense, that is also, well, it's 60 days, but it's a 30 days suspended. So you're doing 30 days. So the only time where you have that increase is if your second offense is basically within 2 years after the first, but within that 10-year time period. That may have been confusing. I hope I got that right. Third offense is a 5-year loss of license with a max of an indefinite suspension. But
Mr. Chairman, considering a driving is a privilege, right, not a right, that's actually I would have to agree with Representative Roy that that's a reasonable request.
I think the concern is that in order for you to prosecute third and fourth offenses, is that the third offense is often not going to occur within the 10-year window.
Let's say on your 20th year, you get arrested for a law. Judge, the crime, you would be charged with a third offense of lie. Go back and 10 years, but they could consider it for loss of license at the end of the year. So you would still lose your license for 5 years.
Mr. Chair, if I may, I don't think we're prepared to sit here and look at rewriting the DUI statutes. I think what the issue here is the 20-year look back. I believe I heard, and I think it's Representative Roy say, is there a different number that you would be willing to entertain?
You guys want 10? I want the 20. I think 15's right in the middle.
We were thinking 8, but
That's the right. I would say that would be a reasonable.
yeah.
Here's the thing. I just, I have to have a reason for us to want to change it. And like, I hear, I just don't see that I don't hear that this is a problem in New Hampshire. Like if this is, I don't want to ruin lives, as Senator French is indicating. I don't want to ruin lives when we don't know that this is actually happening. Like in the House, did you hear testimony from law enforcement, from whoever, that this is happening? And they have the data about it. I would love to see that.
So you're telling me that you want data on whether people are arrested for drunk driving 3 times?
No,
And how-
data supporting the need for a 20-year look back. Data supporting the need for a 20-year look back, or data supporting the need for a 15-year look back. What I'm saying is that we have a 10-year look back now, and that seems to work. And then like, I don't, if there is data to support the need to change the look back, then that's what we need to see.
I'm going to be honest. I'm looking at the time period of how this would play out. Unless you're getting your subsequent offenses without a valid license, I'm just pointing out that it's unlikely. Second offense is a 3-year loss of license. All right. I'm just assuming that you're complying with the law in that time period. It's really 7 years that you're allowed to legally be driving. I'm not counting if the breathalyzer side of it and all that. I mean, there's more that can play into this. And I'm just, for a third offense, we're saying, oh, we don't want to be able to charge them a third offense. We need data to see that. I'm just pointing out it's a third offense. Whether the look back period's 10 years, 20 years, 30 years, it's still the third time they've done it. So is it a problem? Define what a problem is. How many times does it have to happen before it's a problem that we address? I'm telling you, is it happening to the point that this is an emergency and we must deal with it right away? I don't think that's the case. But I don't need to see the frequency of how often it's happening. I just see from a practical sense, the third offense or a fourth offense. All right, if the person needs help, they've had plenty of time to get help. Now, I understand 20 years is, people want to be critical of that. I understand that, at least where they're coming from. I think 15 years would be a reasonable compromise. That's my humble opinion.
I mean, I think that just is a misunderstanding of the way that the disease progresses. You know, you can't put a time frame. I mean, that's a whole separate issue. Giving them enough time to get into treatment. You know, if the goal is to get these people to not do these bad things anymore, we want to give them the time to do the treatment, don't we?
You're assuming that the offenders are an alcoholic again. I
Correct.
already said that.
And also changing well, I mean, if someone is reoffending 3 or 4 times, but there's a pretty high likelihood. I mean, that's what we hear from the treatment folks too. Also, it doesn't address this issue that Senator French is talking about the age difference and how, we mature, right? So if we know, and Senator Carson mentions this a lot too, that brains aren't fully developed till 25. Okay, so you have, 2 offenses even at 25, right? And then you have your third offense. So, it's complicated. And I think of course we're not saying that it's not a problem that they are having third offenses. That's not what we're saying. Correct? What we're saying is that if we're going to change the look back, we need to understand the significance of how much this is happening.
I'm having a hard time following. So a 21-year-old, their brain's not developed enough to the point that they understand that drinking and driving creates a public safety risk. With all due, I have a hard time. We allow them to drink at age 21 legally. If they're not mature enough to drink, I mean, but we're not going to give them the same punishment for drunk driving now.
Well, and we're also talking about the ability to get into treatment too, right?
Chairman, my understanding is a lot of times when a person is in front of a judge for drinking and driving, whether it's a plea or the actual conviction, a lot of times treatment is part of the sentence. A lot of, I think, I've never known it not to be part of the sentence. The fact of the matter is, I think I'm having a hard time understanding how we can sit here and say, well, because a person has this problem, we're going to justify not looking back because they may have had a problem. I mean, it's a problem when a person's coming home from work when they're 18 years old and they get hit by a drunk driver that's done it 3 or 4 times. That's a serious problem.
No, and they're still going to be, and so I think we need to be clear, they're still going to be punished. We're not saying that these people should not be punished, right? That the punishment is still there. We're just talking about the look back, right?
Punishment would be for a first. Punishment would be for a first offense, though. That's the problem we're saying. Is that you're right, they'd still be punished, but as a first-time offender, even though they had been convicted 2 times before. Is there any other crime that we can think of that has a look-back period for subsequent offenses? This is the only one we give this kind of a treatment to, where, well, it's not your subsequent offense if so much time has passed. Every other offense, it's subsequent offense.
Mr. Chair, it's my understanding, and then I'm looking back at the testimony we heard in the Senate, that the 20-year look back is for third and fourth offenses only. So, I mean, when we did this, quite frankly, we were really concentrating on the definition of the word way, because there had been a recent Supreme Court decision on Rudder versus DMV that affected how way was determined, and the Attorney General came in and they were like, we really need this defined. I think that Senator, we will consider an alternate. Is there a proposal for something other than 20 years?
I would propose 15 years.
Okay, so 15 years as a compromise. I think Senator French and I can accept that. I don't believe Senator Whitley can.
Will replace her.
And we can. We can, so my suggestion, Mr. Chair, is to prepare that as a compromise.
And so just to clarify, the House version as written, except for making it a 15-year look back.
Well, we need,
And
we
keep-
need the
keep this-
definition of way,
Yes.
and this is a compromise. You will accept the definition of way, we will accept 15 years, and that's the compromise.
We will accept the Senate section word for word. House
Yes.
version, make it 15 as
Yes.
opposed to 20.
Yes, and we will accept that as a compromise.
So everybody's okay with the definition of way? And why must that be part of this bill?
It needed to be, it was that Supreme Court case, I don't know if it was March or whenever it came down. Right now, with the conflicting definitions of what a way is, that's an element of proving the offense. Do credit the mighty fine defense work that was done to catch that. However, that does need to be addressed right away. Like, that's, so this bill, it was at least according to our friends in the Senate, it would believe to be germane to the topic.
Okay,
The Attorney General did contact me before that hearing, asked me my thought, sent me the case, I reviewed it. I had no problem with it being added. I gave it my blessing to add it. I was hoping my underlying bill would survive as well, and it apparently did not. But I was all right with what the Attorney General was going for. And I think it does address an immediate problem.
it does mention some privately held lands, that's my concern.
So private land can be like, but keep in mind, you go to like a grocery store, it's commercial property, but it's private.
But public has a right of access, that's different.
And it-
That's already the law.
I don't know, we didn't,
We never know.
My concern is actually with the out-of-door
Yeah, okay.
areas,
well, I
Where-
just have a question.
for example,
In the bill, it's section B, beginning on line 28 on page 1. It says, any person convicted of a violation of RSA 265A:2, section I, subsection A, and the conviction is based, blah, 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 or under reasonable equivalent offense in an out-of-state jurisdiction occurring within 10 years of the date of the present offense. So, shall be guilty of a Class A misdemeanor. Do we want to make that consistent between 10 and 15?
So what that was, I think the intent of what that section was, is that if you did get a subsequent offense, what it was doing, a conviction for a first offense is a Class B misdemeanor. This is making it a Class A.
But it also has a 10-year look back.
I just wanted to know what they were doing.
Yeah, so. So if you're gonna use 15, that section would be
15 as well.
15 as well.
Good catch. Or
Good catch.
good catch.
Good catch.
Do we have any issue with that? Yeah. We have no, that, we're okay with that.
Okay.
Thank
so-
you, whoever,
Yep. So we are in agreement.
we're in agreement.
Okay, so we look forward to seeing the report. Thank you very much, Mr. Chair.
And we are done. We will now close the committee conference on House Bill 1333. Just before we break any longer, my friends in the Senate, in respect to HB 307, I'm just gonna reopen that and state the time that we're gonna, because we were kind of on a break, and that's when you said you were available. So if you can do it earlier, that would be, I'm sure that would please. I don't think I said that on, set a time. All right, so we will now just, I have to quickly open it, then say it, and we will now reopen the committee conference on House Bill 307, and we're gonna be on break until 2 p.m. 1476 is scheduled for 1:30. Everyone will be in the same room at least. He hasn't got. Good afternoon. We'll now call to order the committee conference on House Bill 1476. Before we begin, we'll just go around, let everyone introduce themselves for the record.
I'm Representative Ross Berry, represent South Manchester and the town of Litchfield.
Representative Jennifer Rhodes, Cheshire District 15, Winchester, Richmond, Marlborough, Swansea, Troy.
Representative Terry Roy, Rockingham 32. I represent Candia, Deerfield, Northwood, and Nottingham.
Jeb Bradley from Wolfboro.
Donna Susi, Senate District 18, Manchester's Wards 5 through 9 in the town of Litchfield.
Senator Bill Gannon from Sandown, the heart of the wine country of New Hampshire.
Good afternoon, Representative Darrell Abbas, representing Rockingham County District 8. Just before, we have two versions of this. There is what passed in the Senate and there's a version that passed in the House. They're very different. They could technically on their own survive together, but they don't necessarily have to. They address different parts. But if you want to go around and let each side explain their position on each one, we can start. Anyone wish to begin first? Representative Barry?
So 1476 is passed by the House is significantly different than what the Senate, replaced it with. 1476 addresses repeat arrestees, more than likely criminal offenders, but you are innocent until proven guilty. So we're talking, 1476 deals with people who are currently out on bail and are arrested again. If you have an area that has been affected by the bail reform, city of Manchester, Rochester, anywhere you find one of the county jails, you get a lot of the negative effects of the rapid release of people who are arrested committing crimes because they're dumped back out into your community. So somebody who's arrested in Medford or New Boston ends up in my city of Manchester, often to be rapidly arrested again. And if you listen to the patrolmen, whose I've spoken with extensively, they will arrest people who are laughing in the back of their squad car because they know that they will be back out onto the streets before the officer has finished the paperwork. So 1476 attempts to address that and close that so that people can stop flouting the law, specifically in Manchester and our other cities such as Nashua, Rochester. I imagine Concord probably experiences some of this as well. So that is what 1476 deals with. It's on the second arrest for all crimes, and then it's on the third arrest for Class B misdemeanors. That was done as a negotiation with people who were opposed to it because getting a coalition together to pass the House has been well, if you think I worked hard on redistricting, I promise you I worked harder on bail reform in the House. It takes a lot of negotiation, a lot of explaining things, and 1476, when it passed the House, passed, I believe, almost 2-1.
Representative Roy?
Thank you. I just wanted to follow up a little bit on what Representative Conley said. It's Barry, excuse me. Sorry. It's not just certain towns that are, it affects every single town in Hampshire. There's no borders, and even the smaller towns have to deal with this issue, be it people they had to release or people released from other communities. So it affects the entire state.
Representative Barry?
I spoke with a chief from up north who told me that he had arrested the same individual 3 or 4 times, and that individual ended up ODing and dying. And he said, we could have done something for that person, but we just kept taking him in and throwing them back out, taking him in and throwing him back out, taking him in and throwing it back out. This is a real. I think and I wasn't here when the legislator passed the last bail reform package, but I did watch and go through and read all the notes, and I don't think that was anybody's intention. I think the original bail reform was supposed to be targeted towards making sure that we weren't holding poor people for minor crimes. I think that's something we can all agree on. But when we're talking about people who are already out of bail, I mean, these are people who've been arrested in a rapid period of time.
Senator Bradley?
Good afternoon, Mr. Chair. So, as you know, we've worked together on this language. The language that the Senate adopted in House Bill 1476 is your language, Representative Abbas. You gave it to us. We adopted it as is. We obviously consulted with the police chiefs. We dropped the provision in House Bill or Senate Bill 294 that was similar to the provision in Representative Berry's bill at your suggestion, because you thought it would be easier to get it through the House. So I've done, and the Senate has done, everything that you asked us to do. The difference between the two bills is that the language in the Senate version of 1476 actually targets the biggest problem, the violent offenders. I would like to have repeat offenders in, and if it's the will of this committee of conference, we could either make sure that the language of Representative Berry's bill is consistent with, the provisions that you wrote in 1476, or we could go to the language in 294 that talks about repeat offenders. I'm happy to do that, but it was at your suggestion, Representative Abbas, that we dropped it. So I'm good with that because it was your suggestion. But it targets the language in the Senate bill targets violent criminals. And that's where the biggest problem is. And that's what we should be focused on.
Respectfully, when it comes to dropping a section, and with Senate Bill 294, which that section, if that bill as drafted or even some of the amendments that floated around the House would conflict, because it's a much longer, more intensive bill, would have a provision that would conflict with what HB 1476 does. So in what I sent, it doesn't change this section. The reason why is that they conflict. So you can have a debate on just 1476, and then the rest of what 294 would have done, Senate Bill 294. So the idea is to not have, you don't want to have a much larger bill impacting this, because if that bill weren't to go forward, this bill would not have its own.
And that's why, at your suggestion, we dropped the repeat offender provision. And it's not in the Senate passed version of 1476.
I'm referencing 294. 294. I don't want to actually address. The idea was.
I'm just saying that when we discussed 294, which we did quite a bit, and the language that is now in 1476 is what you gave me vis-a-vis 294. So I went with your suggestion to drop the repeat offenses, and we just stuck with your language on 1476.
The reason why I wouldn't change 1470, because what I sent you was an amendment to Senate Bill 294.
Exactly. But the point I'm making is we're willing to accept your suggestion, your so-called compromise, but the more important piece of this entire effort is violent criminals. And I think that's pretty clear. And I think my conversation that Representative Berry, you and I had a couple of weeks ago offline was that if, and I don't want to put words in your mouth, but certainly my memory of the conversation was we should be targeting violent criminals. And that's what the Senate passed version does with the support of the police chiefs who are out there day in and day out defending our communities. I agree. Repeat offenders are a real problem, but I think the larger problem is people that have been alleged to have committed a violent crime, getting bail immediately, and then recommitting another violent crime that they should have been held for and see a judge before they get bailed. And to me, that should be the focus of what we're doing, especially since, Representative, it's your language.
I like it, and I did help write it, but my understand it's getting it over the finish line is the issue, and this passed in the House. I can't even get my language for a discussion on the House floor,
Well,
and
can
I
I
tried
read
very
for you
hard.
what
and
the
no one will
hearing
deny that.
report on this bill in the Senate, if I might, and I think there is, you know, representatives of law enforcement, and maybe you'd call on them to also talk about it. But in the hearing report on 1476, Chief Hobecki said specifically they support Senate Bill 294 because it addresses the issue of violent repeat offenders and how to remedy many of the situations that have occurred. So when they were talking about 1476, they were referencing what the real problem is, violent offenders, in that hearing. That's why, I mean, we in the Senate took your language and put it into Representative Berry's bill, because that's the bigger issue. I agree. Repeat offense is a problem, but I think we should be, you know, targeting the bigger problem.
And just let's understand the two policies here. HB 1476 is passed by the House. What it does, someone's out on bail. There's a couple other, you know, if they're on bail waiting a sentence, whatnot. The person is charged with a Class B misdemeanor, which is by the way, it's a crime that you wouldn't ordinarily go to jail for. Third or subsequent offense shall be detained for a period that's not more than 36 hours. What the Senate version that I helped draft, what that would do, you don't necessarily have to be out on bail. So you can be dealing with a first-time offender, but the crimes that you're dealing with are much more serious. Violent crimes against a person or a sex crime against a child. That's what the scope of what the list of offenses are. And in that case, it's the same thing. It's 36 hours. You're not going in front of a bail commissioner. You're going in front of a judge. Now, the appetite of the House, I will never understand why they would support 1476, but not what I was hoping would be an amendment to Senate Bill 294. But that's what happened. So here we are. So I guess what can we get over the finish line is the question. Senator Susan.
Could I just add something? Because I was actually one of the people sitting around the table when we negotiated the original bail reform. And you're correct that the intent was to ensure that just because somebody didn't have $1 in their pocket, they weren't sitting in jail. Flash forward and living in the city of Manchester and talking to the chiefs and recognizing there have been some instances where, because, and we don't need to get into a whole discussion about the bail commission system, but let's just say the system has had difficulties, I think, handling the bail reform legislation as it currently is, particularly as it relates to extremely violent offenders. And what that has in turn done is made some victims unwilling to participate in the prosecution of the alleged perpetrator. When this bill passed, when 294 passed, but particularly when the version of 1476 passed the Senate, passed on a 21-3 vote. There was one Republican, 2 Democrats that made up the 3, and then obviously the balance of the Senate. So the legislation, as it stands before you, the Senate version, has significant bipartisan support. And just to reiterate Senator Bradley's concern, the concern we were hoping to address was those who have committed violent offenses and ensuring that there was the ability for a judge to make the determination. And I think that's how we got to where we are, at least from this side of the table. And I do recognize that obviously the House reacted differently, but it was clear and it was bipartisan in our support.
Representative Ross? Representative Berry.
Sorry, I've been called worse. No one's wrong here. No one's wrong here. And that's the problem. The addressing the violent offense is something that on a personal level, I would love it if we would do that. And Senator Bradley's not incorrect. I would wholeheartedly support that. In fact, I'd probably go a step further that maybe people here wouldn't be comfortable, and I'd get rid of PR bail entirely. I think I don't like cashless bail. I've made that clear from the beginning. So it's not a lack of will on at least the people that are here for the violent crimes. The issue we have is we have to count votes in the House, and it is something. You had two Democrats and one Republican were the only people that opposed your bill, but I believe, it would be in the hundreds when we had similar language come across to the House. And I'm not speaking. Let me be very clear. I'm not speaking for myself right now. The House majority, of which I was not a part, does not like the one and done. I disagree with them wholeheartedly. I disagree with them, but I also have to live in the reality of counting votes. And we were able to count votes and get 1476 across. I fully acknowledge it's a much higher, easier hurdle to get what I view as the right thing done in the Senate, but unfortunately, there's just no appetite in the House under its current makeup. We have an election in November. Hopefully things will change. Hopefully people will change out. By the way, on both sides, it's not exclusively a partisan issue. There are some partisan lines, but it is not exclusively a partisan issue. When we passed 1476, I had many Manchester Democrats helping me and cheering me along the line. Some of them co-sponsored this. So what I'm saying, the message is the votes do not exist for anything that looks like 294 or 92. I'm also saying I wish they did. I wish they did. And I would fight like hell to get them. In fact, I did. They just don't exist. The votes exist for 1476. I wish 1476 went farther. I wish it had a provision about one and done on violent crimes. I just made my position about PR bail known entirely. I want it gone entirely. But it doesn't exist. And if we continue to push a position that will die in the House, that I cannot control, we are basically saying we are done for the year. We're not going to do anything. We're going to keep letting people out. It's never going to stop. And I know I'm not trying to impugn your motive. I understand your motive. I agree with it, that you want to stop the violent offenses. I'm all in. But I have to live in reality. And the reality is when something similar like this came across and they tabled it, and I believe the table was 2-1. And then when they went to take it off the table, it died 3-1. It got worse. The House is a weird beast. I'm a freshman, but I've learned a lot in 2 years, and I feel like in certain ways I've served like 4 terms in 2 years. But I have learned that once that body makes up its mind and votes one way, moving it is a nearly insurmountable task. And you're asking of us to do something that I just don't know where I'm going to find the votes. I had to do things to I had to water down 1476. You go back and you look at the speech. I even said at one point, I got criticism, ironically enough, from people on the left. I was like, how much more are you going to water this down? I said, until we get the votes. And I stopped when we had the votes. And it just is what it is. And I don't want to leave here with nothing, but you guys need to understand that you're effectively putting us in the all or nothing situation. I know it's not what you want to do. I get it. I totally get that. But it's effectively what's happening. And, I don't know, how long, my city has to scream about this. I don't know how long other cities have to scream. I don't know how long people in New Hampshire have to scream about this. But to us, to walk away from this with nothing is insane. And we need to figure out, I don't know how to convey this. And the chairman ruled me out of order at the time and gave me some indulgence when I said, please God, don't amend this. It was the warning, because I knew we'd end up here, and I knew we'd end up with me pleading with you to understand that the votes don't exist.
Senator Bradley.
So my understanding is when this bill went to the floor, it was without a committee recommendation, and there wasn't a clear path of what was going to happen. So it's a pretty different scenario that we have today, in my view. And I've also served in the House, and I know that it can be difficult to get 201. I understand the dilemma of that. But this is a different circumstance. If we're able to agree today or tomorrow, before the deadline, on a version of the bill that targets violent crime, and we allow the people that are on the front lines of keeping our community safe, that opportunity to talk to the 400 members of the House, knowing that 21 of the senators are going to support it, I think you have a very different dynamic. And I think you should give it a shot. That's what we're asking. Because and you can ask the police folks that are here, the bill that you think you can get passed, you just said it in your own words. You've watered it down to the point that it really doesn't do very much. And it also, I think Senator Whitley's question was pretty appropriate in the hearing of Chief Hobecki. She asked if the bill is not simply addressing those violent offenses, but also victimless crimes. And I don't think we're trying to do that. But this is what Chief Hobecki said. The language in your bill is quite broad, and that is why the chief supported my bill, 294, as it specifically targets violent repeat offenders. This could be problematic to the courts in terms of those engaged in nonviolent misdemeanor level offenses being held for 36 hours before seeing a judge. So I think you should try to give what we know is the biggest problem a shot, and give the police chiefs and those people that support safe homes and safe streets a chance to talk to your 400 members. If it fails, it fails. And then we have an election this year. But to substitute something that really doesn't do very much, I don't know what we're doing. I do not know what we're doing in the middle of a crime wave if we're not targeting violent offense.
Representative Barry?
So, there's some confusion on the chief of police side of it, because my chief of police came and testified in favor of 1476, and in fact, the chief police association was working with me until it made it over to the Senate. So there's some confusion there. I understand they produced a letter, but once again, it comes back to the crux of the argument of they're not wrong. I would love to do the violent crime part of it. They're not wrong. It's just the votes just don't exist. And the House has voted on a similar proposal from the Senate, and it died 3-1. To my dismay, it died 3-1. The Senate has never voted on 1476 as we presented it as a whole. It was changed in committee. And this 1476 came out of committee with bipartisan support, which I believe the similar language in the House did not. I believe it had no recommendation. It can't even get going in the body that is supposed to be most attuned to this issue. So I just go back to, if we know the votes don't exist in the House and we know there's nothing we can do about it, and we've already voted on it 2 or 3 times, something similar, one and done, what are we doing?
We did not, the amendment that passed in the Senate was never voted on by the House. What was tabled was not the language in the Senate amendment. It's very different in that the Senate language in 294 was if you get arrested for any of those violent offenses that were listed, and it even included another offense that we actually, I believe, removed from the list. What that would do is there was a presumption that you were a danger, and that there was a presumption that you would not get bail while being held awaiting trial. Now you could overcome that, but there was an issue people had with the shifting of the burden. Would I help?
But that's one and done. The House, I don't like it, but they have rejected one and done.
But that's not what the Senate amendment is. Completely different. What that does is no presumption that you're not going to get bail and be held awaiting trial. All it's saying is you're going in front of a judge, not a bail commissioner. That is it. If you're charged with any of these 12 offenses, no bail commissioner, judge. That's it.
Correct. Is it one and done?
But I'm telling you what it would do.
No, I understand what it will do. I've read it all. Is it one and done? Is it a one and done system for any crime? Is it a one and done system?
It can be.
So the House keeps shooting this down. I don't like that they shoot it down. I think if you hit your wife, you should not get BR bail. I don't know why the House can't get there, but it can't.
Not an issue. It's not an. We're not discussing PR bail. What has
no. The PR bail is in all of these.
Before we're going to take a short break here.
Okay.
Committee will be on a break.
Fine, it's across. And then we're gonna have to use state funds to get this across.
Can you hear me now?
This is your place, not
No, we're
ours,
good.
so we're good.
Set. I want to be closer to the door.
What I would like to see is before the State House bought this building, where do they have all the hearings?
Across the street, at the State House, wherever it is, I think it's that way. Yeah, in the State House. But don't forget, Representative, they didn't meet. They only met like 1 year out of the biennium.
I would love to bring this Texas stuff.
You know, to be honest with you, I wouldn't mind that either, but it would be a jam-packed 6 months. But people would have to exercise discipline and not file 30 bills.
Absolutely.
Well, that's what they told us to sit, so we're in your house, we have to sit where you want us to sit.
We're now gonna reconvene the committee conference on HB 307.
Thank you very much, Mr. Chairman. Unfortunately, I think we are at an impasse. The Senate cannot go along with the House version. We could go along with including use, but only under the conditions of defining public and private use. And unfortunately, we do not have the time to do that here. So my suggestion is that in the upcoming session this year, that we come back with a bill that will define both public use and private use. Thank you very much all for your time. We really appreciate it. It's always a pleasure working with Criminal Justice Committee, and thank you very much.
Thank you.
Representative Burt, yours to make a comment.
Thank you, Mr. Chairman, and thank you, senators, for what you just said. And from what I understand, that Bo does have a carve out on some public land that does not allow shooting. So that can happen if you want to address that at some point. You know, that was brought to my attention today.
Yes, thank you very much, Representative. And I agree. I think we can all see that this is not an easy issue. It is fairly complex, and we just do not have time in the committee of conference in order to address it, to make sure that gun owners, their rights are respected, as well as the municipalities. So I think this is going to be an ongoing process with more discussions in the upcoming legislative session, and hopefully we're going to be able to resolve it next year.
And lastly, it took me 3 terms to get my snowmobile bill passed. And with your help this year, it is going to the governor. So I think
Glad
it'll
we
pass.
could help.
Yes.
Glad we could help,
So
Representative.
things do take time.
Yes, it does. So thank you all again very, very much for all your time and all your work. We really appreciate it, and we will look forward to hopefully working with all of you next year.
If I
Thank you
just
very
may
much.
make one suggestion, the issue of use, I would recommend putting on a separate bill and let that
Yes,
have be its own discussion. It can
yes,
get a
I would
little-
agree.
Things can get very confused in the House.
Yes, I agree. I think that is a good suggestion. So again, thank you all very much.
Thank you. At this time, we'll now reconvene the committee of conference on House Bill 1476. And what I think what we're gonna have to do is we're gonna recess until tomorrow afternoon. Is there a, I hope everyone's available.
Sure.
1 o'clock.
One
Maybe-
o'clock it is.
Maybe Representative, you'll find, if you put this out to your body, all the voters in my district, think I speak for the chief here and most of the chiefs, they want us to address violent criminals and target them. And they would like this passed. Do we have the wrong House members? Maybe we need a different body next fall if they're willing not to support this. All right, the Senate version.
You can't even get the conversation out of the committee, never mind for a discussion on the House floor.
And then
So
we,
that's how bad.
then we have the wrong committee.
Well, no one will tell you that I didn't work my hardest.
I'm not saying you didn't. Okay,
So I get the horse in the stream. That's what I'm good at.
okay.
Just getting it to drink.
We'll see you tomorrow. Thank you.